And a very good morning to you. This is John Fradgley from the Bell Legal Group, back with you for another program of The Law and You this Tuesday morning. As always, it's your opportunity to get free legal advice between now and 9:30. That's 10:30 Tweed Coast time. All we need you to do is get on the telephone, 55208888, that number, 55208888. If you're south of the Tweed River, of course, you need to put 07 in front, but otherwise, Tweed heads and right up the coast, you'll get straight through, 55208888. Don't forget, of course, we do have our email address, talkback@4crb.com, and we did have an email from last week, which unfortunately I didn't get time to get to during the program, but I did send an email response off to Janice, who had emailed in, and I'll comment on that a little bit further. But enough of that. We've got someone who's been very quick out of the blocks this morning, and we say a very good morning to Gary. G'day, Gary. How are you?
Yes, it's Gary.
Yes, Gary. How are you?
Oh, not too bad. How's yourself today?
I'm exceptionally well. All the better for talking to you.
Oh, thank you.
How can I help?
Okay, I've got two questions.
Sure.
One to do, firstly, with the power of attorney.
Yep.
Okay, unfortunately, I had a bad experience with a sibling with my own mother and stepfather's power of attorney, so I don't want the same thing to happen.
Right.
Okay, I have two sons. One's in Aussie and one's voluntarily overseas.
Mm-hmm.
I want to do up a power of attorney for myself and my wife.
Mm-hmm.
Then one thing, like he's 12,000 kilometres away, something comes up in the sense that, it might be illness or something like that happens, and where we have to get into accounts or have to pay for things and things like that.
Mm.
How do I go about by giving one that instant thing to be able to do something where the other person who's away in another country can therefore still have control as well? Can that happen in a power of attorney?
Well, what you could do is that you could appoint, I presume that what you'll be doing in the first instance is you'll be appointing your wife and your wife will be appointing you. But if your spouse is unable or unwilling to act, then your sons will then take over at that point in time. One of the things that you could do would be to appoint your sons jointly and severally, which means that either one of them can sign, but you would have to be satisfied that you have total confidence in your son who lives in Australia, because from a practical point of view, he'll be the one who'll be who'll be signing the papers and making the withdrawals, etc., because your other son is overseas. What you could possibly do, if you want to make sure that the son overseas can keep an eye on things, you might be able to organise that he has view-only access to your bank accounts online, so he could keep an eye on what's going on with the bank accounts through a view-only account. Or if you want him from overseas to be able to operate on the accounts, you could set it up so that he actually has a right to operate on the accounts as well.
Okay, that's good advice. Thank you.
Yeah. So the way you would do it is you would appoint you would appoint your wife or yourself under her power of attorney in the first instance, and then simply if the person appointed is unable or unwilling to act, then that's when the power of attorney for your sons comes into play. Or the other thing you could do is that you could appoint your spouse and the boys all jointly and severally, so that any one of them could sign. That would then take away the problem of loss of capacity, because if for example, you appointed your wife and she lost capacity, and you've already lost capacity, there would need to be a doctor's certificate to say that your wife has lost capacity before your sons could act. Whereas the other alternative would be to appoint them all together so that any one of them could sign, but you could have an understanding with them, that with your sons, that while your wife is okay, or while you're okay to act as her attorney, that they will simply sit on the sidelines and wait until they're required to act.
Oh, right. That's good advice. Thank you.
Okay, Gary. Well, all the very best. That was question one. Did you have a second question?
The second question is to do with the will.
Yes.
Now, I have a difficulty there with one son who has, we have a grandson.
Yep.
And he's actually our grandson, where I suppose a lot of people now, they get up and they have a partner who has children, but they're not his children.
Yep.
Okay, so what's happening is when we want to do the will, we want that's fine to give 50-50 each way to each son, one 50.
Yep.
If one passes away, which would be the one who's got the instant family, we don't want them having that 50% of money.
Right.
Can you follow me there in the sense that...
Yes. So what you want is a situation where if the son who's got the instant family fails to survive you, that what you were going to leave to him doesn't automatically go to the stepchildren. Or alternatively, if he does survive, but then passes away, what he has is not going to go to the stepchildren. Is that correct? Okay, so the way you would need to do...
For his partner, yeah.
Yep, so the first thing you could do is you can put a provision in your will which says that if your son fails to survive you, that the provision going to him will not automatically flow to residue. There is a specific method of dealing with that and a provision under the Succession Act that you need to exclude. Alternatively, if you don't want your son, whatever's left to the son, to end up in the hands of his wife and the step-grandchildren, you would need to leave that share on trust to him. So you'd need to set up a trust. But they're things that you really need to talk to your lawyer about, Gary. All right, then?
Yep, thank you for that information and appreciate, and all the best to you.
And to you too. All the very best. Cheers now. Time on 4CRB is just coming up to 13 minutes past 9. That's past 10 on the Tweed. As we say, a very good morning to Beverly. G'day, Beverly. How are you today? Hello, Beverly.
Hello?
Yes, Beverly. How are you?
Yes, Beverly. Not too bad, thank you.
How can I help?
Am I speaking to John?
You are indeed.
John? Yes, John. My daughter is running her father's business. He's been put into hospital seriously ill and probably won't be able to run the business. She's not coping with it. Wants to close down the business, sell all the stock and close down. What would be her first movement to get that started?
Well, is she wanting to close the business down, or are you wanting to sell the business? Is the business capable of being sold?
Well, probably not, no.
Okay.
No.
All right, because...
Sell all the stock and get out because she can't cope with it either.
All right, because the first instance would be if you want to maximise what you can get out of it. If the business has been established for some time and it has good turnover and a good client base, which means it would have goodwill attached to it. Obviously, the best thing to do is to sell it. But if it's a business where simply she wants to close it and cease operations, what I would suggest that she do, is it run out of business premises or is it run from home? Or
no, it is run out of business premises, and I think there's quite a bit of rent outgoing as well.
Okay, all right, okay. So what she needs to do is to get both legal advice and accounting advice in relation to it. Whereabouts on the Gold Coast is she?
She is down near, just past Burleigh.
Okay. Well, look, there's the, what are they called? The Gold Coast Community Legal Centre and Advice Bureau. Have you got a pen handy?
Yes, I do.
Okay, so their number's 55329611. If she wanted to get some, 55329611. If she wanted to get some initial specific advice, give them a call. They run visited centres up and down the coast, so she could find one that's convenient to her. Go in there and get some legal advice. The alternative would be that she could go along to the to what used to be previously called the Robina Community Legal Centre. It's now called My Community Legal, and that operates out of the Gold Coast City Council Robina Community Centre, which is just on the west side of the Robina Town Centre. They operate every Thursday night from 6:30 to 8:30, and there's no need to make an appointment. You just rock up there, and I would recommend getting there as early as possible. And again, you can see a lawyer there and get free advice, because there are things that would need to be looked at, such as the lease on the premises, if there is a lease, and what would need to be done in relation to that. What sort of entity the business is being operated under, whether it's under a company or it's under your husband's name as a sole trader, which would all be questions that would possibly affect the liability issues in relation to the debts of the business. The other thing, presumably your husband has an accountant that has done the books for the business.
I would presume so.
Okay, because the other thing would be to certainly be liaising with the accountant as well in relation to it, because one of the things, if it is operating as a company, one of the very first things that your daughter needs to be conscious of is to ensure that she is not allowing the business to continue to trade whilst it's insolvent, because if she does, she can be personally liable for debts incurred after the point of insolvency. So that's why it's important to get legal advice as soon as possible, and also to speak to the accountant who's been looking after the books of the business as well. All right then?
All right. Do you have that number for the Robina legal?
Look, I'll give you there is a mobile number. It's 0423 466 286. But it's my understanding that you simply arrive there at between 6:30 and 8:30, and there are a number of lawyers there who volunteer their time, and they will allot you to one of them who'll talk about the problems you've got.
Could you tell me again where that was exactly?
It's at the
Robina?
Gold Coast City Council's Robina Community Centre. So it's on the west side of the Robina Town Centre, immediately to the north of the Robina Anglican Church. And there's a block of offices there, and then you've also got the Robina Community Hall as well, and the Robina Library. So it's all in that precinct, and the offices, as you drive in the driveway, the offices are on the left-hand side.
All right. Now, you did say something about trading while insolvent. If she was doing that, is there consequences for
Well, that's only a
her?
problem. It's only a problem if your husband's entity is a corporation. If he's operating as a company, then there are provisions under the corporations law that you can't trade while insolvent, and that can strip away the corporate veil of limited liability and expose directors to personal liability for debts incurred after the business or the company started to trade insolvent. All right then?
All right, thank you.
Okay, Beverly, all the very best. Time on 4CRB, 18 and a half minutes past 9, past 10 on the Tweed. And we say a very good morning to Barbara. G'day, Barbara. How are you today?
I am well, thank you. I have only one question. I would like to know what makes an estate become liable for probate.
Well, it'll depend on the assets in the estate, Barbara. So as a rough rule of thumb, if there's more than $50,000 in a bank account, the bank may require probate. If there are shares held in public companies, depending on the quantity of shares held and the registry they're held with, that may lead to a need for probate. And the other one, of course, is if the person is residing in a nursing home or a retirement village and have paid either a RAD, residential accommodation deposit, in a nursing home, or they've paid a bond or a purchase price to the operators of a retirement village, then in 99% of cases they will require probate before they'll release the RAD or the bond that has been paid.
Apart from the cash, if there's property?
Only in New South Wales. So if you live in New South Wales, you do require probate before you can transmit a property. In Queensland, you can still transmit a property under the terms of the will, but without the need for probate.
That's what I needed. Thank you very much.
Okay, then, all the very best, Barbara. And the time rolls along, 20 minutes past 9, past 10 on the Tweed, and we say good morning to Ruth. G'day, Ruth. How are you today? Ruth, are you there?
Oh, hello. Yes, I'm here.
How can we help you today?
It's just a quick question. I've got two married daughters who at the moment are really going through a very, very bad time financially. And I just wanted to know how much am I allowed to give them a year, transfer to them a year. We're retired.
Are you on the pension?
Yeah, a limited pension, a limited Australian pension.
Right,
yeah.
okay. Well, look, from memory, the total amount that you can give away in any 1 year is $10,000. And I think so that'd be $5,000 to each daughter, and a maximum of $30,000, I think, from memory, over 5 years. But what I would suggest you do is give Centrelink a call and just double check with them, or you can take a look online. It is also on the internet as well. If you would look up if you just Google how much can I give away each year as a pensioner, it'll come up and tell you what the allowances are.
Oh, okay. Well, thanks very much for that. Not very much, is it?
No, it's not much at all. So you just need to be very aware of it. It's a bit of a trap for young players.
It is. Okay. Thanks very much for your help. You have a good day.
You too. All the best. And the time, goodness, 22 minutes past 9. As we say, a very good morning to Janine. G'day, Janine. How are you today?
Good, thank you. How are you?
I'm very well. How can I help you?
Okay, I worked for a company that had various departments under different umbrellas.
Mm-hmm.
One of the umbrellas went into liquidation, and the company didn't pay my superannuation. So I went to the ATO and everything, and apparently there was nothing that I could do.
Mm-hmm.
However, they are now or still operating under another one of their umbrellas. That makes sense.
Right.
Is there anything that I can do? It just seems so unjust.
It does seem unjust. The problem, more than likely, Janine, is that you were working for one company, and that's the company that was your employer, responsible for the payment of your super, and has failed to pay your superannuation, and they're now trading under another company, which is a separate legal entity, because companies are separate legal entities. And so one company A is not liable for the debts of company B in those circumstances. What I would suggest you do, I would have thought that there would be some liability attaching to the directors of the company, at least for prosecution for failing to pay the superannuation. So that would be possibly one avenue that might be worth exploring. You said that the ATO basically told you there's nothing that you can do. Was that right?
Correct. They researched it and, did investigate it and whatever, and then about 3 months later came back and said, well, we can't do anything to help you.
Right, okay. Look, the only other thing that I could suggest that you do in relation to it would be to get in touch with the Commonwealth Ombudsman's office. Okay. Have you got a pen handy?
Yes, I do.
Okay, so their number is 1300 362 072.
Okay.
Or alternatively, the Australian Financial Complaints Authority. They may be able to assist as well. Their number is 1800 931 678. So give them a call. I suspect from what you're saying that it may be that it may be that the directors of that company have declared themselves bankrupt or something to avoid personal liability for the civil debts. That doesn't necessarily mean that they'll escape liability from prosecution for breaching the law in relation to the requirements to pay superannuation. So they would be the two things. What part of the Gold Coast do you live?
I'm in Coomera.
In Coomera, okay. Well, look, the other thing you could possibly do would be to also call and make an appointment to go in and see the Gold Coast Community Legal Centre and Advice Bureau. They do run centres, visited centres up and down the coast. Their number is 5532 9611.
Okay.
And if you rang them, they could tell you where and when they have a centre operating up your end of the coast, and you could possibly go in and have a chat to them.
Terrific. All right, thank you very much.
Okay, Janine, all the very best. And the time is 26 minutes past 9, past 10 on the Tweed, as we say good morning to Philip. G'day, Philip, how are you?
I'm fine.
How can we help you today?
Oh, thanks. Under New South Wales law, is there any real purpose in deferring getting probate noted?
Well, if someone's passed away and you require probate to deal with the assets, then it's beholden upon the executors to proceed to obtain probate as soon as is reasonably possible, because until you have probate, you can't deal with the assets. The only problem might be, for example, in circumstances where the executors don't have access to funds to pay for the application for probate. But my experience is...
There's no problem there.
Okay, well, no, there is no reason why you should really defer getting probate, because it is an obligation on the executors to ensure that they apply for probate as soon as reasonably possible.
And there's no sort of stated must be done within 6 months or 2 years or...
No, there's no
whatever
requirement for it to be done in a particular period of time, as far as I'm aware. But if the executors fail to obtain probate within a reasonable time, then a disaffected beneficiary would be entitled to bring an application to the court to have an administrator appointed to the estate because the executors have failed to fulfil their duty. So if you're in a situation where this is happening to you, what I would suggest you do is either you or your solicitor write a letter either to the executors, or if they have lawyers acting for them, to those lawyers, saying that you consider that they've failed to act or discharge their duties as the executors, and unless they give an assurance that they're going to apply for probate within a particular period of time, that you intend to bring an application, and that you will seek an order for costs against them for failing to fulfil their duties. All right then?
Okay, John. Thanks so much.
Okay, all the very best.
Bye.
28 minutes past 9, and we will say a very quick hello to Brenda. Hello, Brenda, how are you? Brenda, are you there?
Yes.
How can we help?
I'm just wondering, I have a will just to my son, but now he has 2 children, and I've got investments in their name and mine. And if anything happened to me, 2 of those investments would go to their child because they're 19, but the other 2 would go into my estate, I think. And I was wondering if do I put it in the will? Does that make a difference?
You want those investments to go to the grandchildren?
Yes.
Yes, well, you would need to put it in your will. So what you need to do is basically consult your solicitor and just go through the circumstances and outline what you want, and your solicitor will be able to put that into a form which ensures that those funds do end up with the grandchildren.
Yes. The other question is part of the one you just had. Now, you apply for probate, but what actually is it?
Probate is simply the proving of the will. So it's an application to the court. It's advertised, and once probate is granted, anyone dealing with that will knows that they can safely do so because the court has said this will is the genuine last will of the deceased.
Oh, okay.
All right then.
Yes, thank you very much.
Okay, Brenda, all the very best. And that's about all the time we've got for today. Unfortunately, I won't get time to get to the email that we had last week from Janice, which related to smoking and smoke drift in strata title buildings, but I'll comment on that next week when hopefully time will permit. John Fradgley from the Bell Legal Group, it's been great to be with you. I'll look forward to being back with you again next week, but until then, goodbye and God bless.